Okay. Good morning, everyone. Thank you so much for joining us. I'm Jerry Lynn at Watermark Land Transfer, and delighted to have you with us today for a short webinar entitled "A Matter of Life and Death: How Should Your Clients Take Title to a Property?" Um, it's obviously this is going back to some of the things you might have learned in your ABCs for when you became a real estate agent, but it's important to review these, especially the consequences these things might have for your clients and how you are able to look after your clients. Why should agents care about how a property is titled? Well, you need to be able to competently explain differences between types of deed vesting to your clients. You need to be able to explain how it would affect your clients if they owned title as a married couple versus owning only as joint tenants. You need to prepare your clients for how your proceeds might be distributed at closing. You don't want to have any nasty surprises because the way that they thought they were on the deed is not how the reality actually was. You also want to make sure you help protect your client's best interests. And you can do that by properly explaining the different ways that they can take title. And your client actually should be making the choice about how they wish to be vested on a deed. It should not be your decision, naturally, because we are not lawyers and we don't want to be accused of the unauthorized practice of law. So we should be explaining differences and having your clients make the selection. Additionally, as a realtor, you need to be able to get in touch with all titled owners of a property, especially if you are the listing agent, and be able to pass that contact information on to the title company. So let's go on to the next slide. What do we mean when we're talking about title? Well, title refers to how a person or an entity rightfully and legally owns their property. Of course, an entity would be a corporation, a partnership, legal limited liability company. Title can be held by more than one person or entity, naturally. And a person does have to be a legal adult, at least 18 years of age, to be a title holder on a deed. And you can see we have a short sample of a deed listed here. Between the simplest form of title would be granting title from one seller to one buyer, as an example here. So what are the ways that people can take title to their property in Pennsylvania and in Maryland? Well, you can take title as a sole owner, which is self-explanatory. You can take title as tenants by the entirety, which would be married couples only. This is a special type of vesting that's reserved strictly for folks who have been married and are married at the time that the deed would be vested into their names. You can also take title as joint tenants, and finally, as tenants in common. The vesting on a deed is extremely important, and your title agent is a little obsessed with this topic because it affects so many things relating to property ownership. It affects families, it affects how their estate is managed, and it also affects the seller proceeds, as we'll see in a few examples down the road here. So you never ever want to take vesting lightly. It is extremely important, and it's one of the number one things that we're going to look at as soon as we receive a contract from you. So let's talk about being a sole owner, the simplest form of deed ownership. A single person can take title as the only owner of a property, or a married person can take full title as the sole owner of a property. Now, this is very important. When a married sole owner sells, they have to affirm that they're not separated from their spouse or subject to a divorce proceeding. If they're married, it's very likely that we're going to require their spouse, who is non-titled, they're not on the deed, but we're going to require them to join into the deed to convey the property to a buyer. And why is this? Well, you might have been disappointed, for example, by the title agent telling you in the past that, oh, I know that only Mr. Smith is on title, but we're going to require his wife to sign too. And a lot of people get upset by this, but The reason is that Pennsylvania, and also Maryland, by the way, is a former Dower and Courtesy state. Now, in Pennsylvania, the law still recognizes spousal rights in lieu of those ancient doctrines of Dower and Courtesy. And you might recall this from your real estate classes back in the day. Basically, a spouse does have an interest in real estate that's owned by the other spouse. And it says to the extent of the use of the marital assets for purchase of the property, for example, and to the extent of any appreciation of that property during the marriage. However, Pennsylvania title insurance companies, and I can speak for myself definitely, do not want to determine the nature or extent of the use of marital assets in the purchase of property. So the title insurance company is going to require the execution of a deed or maybe a spousal waiver or a mortgage by that non-titled spouse. So the same issues crop up regarding spousal signatures when a property is being sold. Even if one spouse owns the property in his own name, the deed will need to be executed by both spouses to eliminate the spousal rights in lieu of dower or courtesy as a potential title claim in the future. We're trying to protect your buyer's best interests by making sure that the non-titled spouse can't come back in the future and lay a claim like against the assets. So, real estate refresher for you agents out there. What is dower and courtesy? Again, it's the surviving spouse's right to receive a set portion of a deceased spouse's estate. Dower refers to the portion that a surviving wife is entitled to, while courtesy refers to what a man can claim. Now, in modern life, the Pennsylvania Uniform Probate Code has pretty much replaced the dower and courtesy system with new rules that include the surviving spouse as an heir in the line of succession. This is all beyond the scope of what we're trying to discuss today, but I just wanted to put that out there so that you would know that there are modern rules in place to replace dower and courtesy. However, title companies still want to make sure that the non-titled spouse signs off. So again, that there's no claims by that non-titled spouse in the future. In Maryland, dower and courtesy have been replaced by the spousal election law. It's still advisable to have a non-titled spouse sign off as a seller on a deed upon the sale of a property because, again, this is protecting the buyer's interests, your buyer's interests. It's better for us to be too careful and to make sure that we've captured any possible situation where a non-titled spouse might have an interest in that property by getting them to sign off. Sometimes it's a pain in the butt, but we have to pursue it in order to protect your buyer. Now, a second way that folks can hold title to a property is tenants by the entirety. This is a special category of deed vesting, which is limited to married couples who are married at the time of purchase. Now, the deed typically has to have the magic words husband and wife, married couple, or tenants by the entirety. And of course, same-sex marriage is legal across the United States. It could be simply husband and husband, wife and wife, or however that couple might choose to be vested. I have the language on the deed. Tenants by the entirety have the right of survivorship. This means that if one of the spouses would pass away, the surviving spouse will take title to the property automatically by operation of law and own it by themselves. Now, tenants by the entirety has a unique feature. It creates a marital shield against most liens, which means that if one of the spouses would have a judgment against them, the property can still be sold without the judgment having to be paid at closing, because the tenants by the entirety vesting status acts like a shield to deflect judgments that might try to attach to the property. And we'll talk a little bit more about this later. There is one exception though, guys, the IRS. IRS liens against only one of the spouses will pierce that marital shield and they must be paid at closing. So you got to hand it to the IRS. They've thought of everything. Okay, what states recognize tenants by the entirety? Well, not all states do. There's only 16 that recognize this special category of deed vesting. And you can see here that Maryland and Pennsylvania are two of them. Now, how could tenants by the entirety be severed? Well, we already discussed the fact that tenants by the entirety, one of the great features of it is the right of survivorship, where if one of the spouses would pass away, the surviving spouse will still be vested as the automatically, just be vested as the sole owner. So if one of the spouses dies, that does sever the tenants by the entirety vesting status. Also, if a final divorce decree would be entered, that would also sever the tenants by the entirety vesting status as well. Just because a couple might be separated does not sever how their deed vesting is. They could be separated for years, but still be vested as husband and wife on the deed, and that's totally fine. They could have filed for divorce. They're still vested as tenants by the entirety if something would happen. It's not until the final divorce decree is entered that tenants by the entirety vesting status would get lost. We discussed about this too just a moment ago. Under tenants by the entirety, because of the right of survivorship, if a spouse passes away, title automatically is granted to the surviving spouse by operation of law. A new deed does not have to be done if one of the spouses dies. The law will still recognize that the surviving spouse is the sole owner of the property.
Hey, Jerry, I have a question. What about when, someone bought a house prior to them getting married, but now they're married? When we're doing contracts, does that person have to be on the contract, or they just simply need to be at closing to sign off on the deed?
Well, technically, since they're not on the deed, they would not have to be on the contract, but at closing, they will have to sign off, yes.
Okay, and then what about if they was a married couple and then one passed away?
Mm-hmm.
Do we, when we're writing contracts, if it's still showing up in public records and the deed as like the deceased person's name on there too, do we add their name, or do we just put?
No, it's a great question. You would not have to add their name, since
Okay.
it recognizes that there's sole ownership there now.
Okay.
Great question. So let's talk about the interest that's held by tenants by the entirety. Spouses who hold title as tenants by the entirety hold the entire interest of their ownership as a whole, as if they are one unit. And that's what also makes tenants by the entirety vesting so special. Therefore, because they are considered to hold title as simply one unit, one spouse may not mortgage his or her interest alone. The other spouse must also sign the mortgage. So we get a lot of questions from some agents about whether or not suppose husband and wife own a house, but only the husband's getting a mortgage on the property or just putting it in his name. The wife does have to show up at closing because she's on title. And even though she might not be on the note, the promissory note, she will have to sign off on the mortgage, which would indicate that she's aware that there is a lien on a property of which she is a part owner, of which she is an owner. Here's a question for you guys. Chrissy Teigen and John Legend have been married for 2 years, and they finally decide to stop renting, and they're going to buy their first house together. The deed at closing does not specify their tenancy. What is the tenancy?
Joint?
A couple seconds to think about that to yourselves there. Answer: they are tenants by the entirety. If a couple is already married when they purchase a property, but the deed, for whatever reason, does not specify how they took title, the law will provide that tenants by the entirety is implied. And this can simply be proven with a copy of the marriage license. So if we ever ask you guys to get a copy of your client's marriage license, we're trying to determine that they are holding title as tenants by the entirety, because it might be possible that the deed that vests them is very vague. So we're just trying to make sure that we protect the rights of your clients and give them all the due benefits that they're entitled to. So again, if the deed doesn't specify what kind of tenancy that a married couple owns the property with, as long as they're already married when they purchase the property, then we will assume, and the law provides, that they will own it as tenants by the entirety. Now, here's an interesting, very important thing for you guys to know. Under tenants by the entirety, if spouses divorce each other, they will now automatically own the property as tenants in common. If a new deed is not done, then tenants in common will be the default title setting. So, what is tenants in common all about? Let's jump into that. Tenants in common is when two or more people own property as an undivided fractional share. So you might have maybe 2 or 3 partners that own a property together as tenants in common. Each of them might own a 33 1/3% of that property, or 4 people might own 25% of that property, for example. Each owner would own a specific share. And here's the most important thing about tenants in common. There is no right of survivorship. Heirs of the deceased owners will end up sharing ownership with the surviving property owners. The property will not go entirely to the owners who are left, but instead the deceased owner's share will pass according to their will. So this means that the ownership share of the property, again, gets passed to the heirs. So if you have a situation where a husband and wife who owned the property as tenants by the entirety, suppose they divorce, and maybe it's a rental property, so it's not their primary residence. They just have this rental property that they're going to continue to own together, and they're getting income from it, and everything's fine. Each of the husband and wife, maybe they each remarry in the future, and then there's more kids to the new marriage. So there's a lot of stepkids involved now. If the former husband and wife, if one of them passes away and they never updated the deed, they might be very surprised to learn that they will actually now own the property with their deceased ex-spouse's children. So it's very important to make sure that your clients are looking at their deeds and making sure that they're not creating unforeseen consequences for themselves in the future when they're doing estate planning.
Hey Jerry, where can we see if someone does own it like this, the percentage that they own? Is that on the deed?
Yeah, it will be on the deed. It will be on the deed, yes.
And is this what would be used if it was like boyfriend and girlfriend, or is that joint tenants?
It'll be joint tenants, so we'll talk about that one next. Yeah, that's a good question. So if tenants by the entirety is severed by divorce, tenants in common is automatically created. And this is one of the reasons why attorneys will urge their divorcing clients to redo their deed, or to refinance and have one of the former spouses buy the other out, because leaving a lot of times married couples who don't do anything about their deed are unfortunately setting themselves up for a nightmare scenario in which they will own the property with their ex-spouse's heirs. And that can get kind of messy, as you might imagine. So with tenants in common, any of the owners can part with their fractional share legally without needing the consent or approval from the other party or any of the other owners. When no tenancy is specified, tenants in common is the default setting. So if you decide to buy a rental property with your friends and you don't specify your tenancy, the law will provide that you all own it as tenants in common. So as we just discussed, if ownership is not specified on a deed, then tenants in common is assumed. Tenants in common, again, is the default tenancy when none is specified. So again, you want your clients to be very careful if you are actually representing spouses who will be divorcing. It's important to check the deed. And agents too, when your clients are the buyers, it's an excellent practice, and I believe this will set you apart from other agents, if you check your buyer's deed at the closing table, just to kind of see, you know, oh, yeah, yes, they're taking title as husband and wife. That's exactly what we want. Or no, actually, they're just taking title as joint tenants. My clients are boyfriend and girlfriend. They're buying their first house. We just want to make sure that it does say joint tenants. So it's a good practice to just check that deed at closing and make sure you're in contact with your title agent about the vesting of your clients. It's a great service to perform for them, which, to be honest, a lot of agents never check into this. So it's a good practice, though, again, it'll set you apart. So here's a question for you. We have unmarried couple, Kurt Russell and Goldie Hawn. They buy a house together. They're not married. Their tenancy is not spelled out on the deed. How did they take title? As tenants in common. Again, unmarried couples who take title to a property without specifying how they'll be vested will automatically be considered tenants in common. Again, if one of them passes away, their heirs will end up sharing ownership with the surviving owner. So again, that could lead to unintended consequences. So it's really important that you're able to explain this to your potential clients who might be getting divorced. Let's talk about joint tenants. This is the fourth kind of tenancy on our list. Now, joint tenants have the right of survivorship, and often you'll see joint tenancy written as, and I quote, joint tenants with the right of survivorship, end quote. Joint tenants will own the property on the same undivided share of the whole. There's no fractional ownership with joint tenants. All of them take title at the same time and on the same deed. Joint tenants are governed by the 4 unities of time, title, interest, and possession. All 4 of these will be the same, and there's no fractional ownership. And with joint tenants, if one of the joint tenants passes away, title is, their share is simply absorbed by the other title holders. Here's an example. We have the Kardashian sisters. So we have Kim, Khloe, and Kourtney, who all purchase a property in Beverly Hills together. They're vested on the deed as joint tenants. One of the sisters tragically passes away 2 years later. So what happens to Khloe's interest in the property? Answer: Kim and Kourtney are now the remaining joint tenants. They've absorbed Khloe's share. A new deed does not need to be done because, again, the law assumes and presumes that the surviving tenants are now the remaining owners. There's no shares here that get left to descendants or heirs. So a quick review. What is the right of survivorship? Again, this is where property will pass to the surviving joint tenant, or of course the surviving tenant by the entirety, the surviving spouse, on the death of another joint tenant by operation of law. It just means it happens automatically. Now, property interest does not pass through the deceased person's estate, although it's maybe possible that inheritance taxes would be due, which is a discussion that's beyond the scope of our webinar today, but it's just something that you might want to keep in mind if a client might ask you. So, marriage after vesting. So, very important. Title vested as tenants in common or joint tenants will not automatically become tenants by the entirety just because the tenants get married. A new deed would need to be done to enjoy the additional lien protections that you get as tenants by the entirety. Because don't forget, one of the marvelous benefits of being vested as 2 spouses together as tenants by the entirety is that you have some lien protection if one of the spouses maybe runs into financial trouble and gets credit card debt against them, and they have judgments, for example. The property is protected from the liens against one of the spouses. So that's why it's very important to look at a deed to see how your clients are currently vested, because we have a few examples of what happens. So Tom Brady and Giselle Bundchen bought a house together in 2007 before they were married. The vesting of the deed said that they took title as joint tenants with the right of survivorship. Then Tom and Giselle married in 2009. Are they now automatically vested as tenants by the entirety? Well, the answer is no. A new deed must be done. If boyfriend and girlfriend take title to a property as joint tenants, if they get married later, it does not mean that they are now tenants by the entirety. A new deed has to be done. The law still looks at them as each of them being joint tenants on that property. Here's a different kind of scenario. Tom and Giselle buy a house together in 2007 before they're married. They were vested as joint tenants because they weren't married. They get married in 2009. They do not do a new deed to show that they're now husband and wife. And then Tom racks up a bunch of credit card judgments because he has a lot of reckless spending and unpaid bills. As a result, Tom and Giselle have to sell their house. Do the judgments have to be paid since they're married? Well, let's go back and review how they took title, guys. They were vested as joint tenants with the right of survivorship because they were not married when they bought the property. They never did a new deed to show that they are now husband and wife and wanted to own it with the tenants by the entirety's protection. So that means that there's no marital shield. The judgments will have to be paid out of the proceeds of the sale of the house. So this means that as an agent, you will need to account for these potential judgments in your estimated your seller net sheet. It's very helpful to know whether judgments might have to be paid by examining the existing vesting. And how would you find this out? Well, you would partner with your title agent to find out if there are judgments against your sellers and to find out how the sellers actually hold their title. If they got married after taking title originally and never updated their deed, any judgments against the property are going to have to be paid if they're against only one of the title holders. If anyone needs more clarity about that, please feel free to let me know and I'll be happy to explain. As another example, Tom Hanks and Rita Wilson had been married for 20 years and they decided to buy a house together in Haynes Acres as husband and wife. Rita has judgments filed against her in Pennsylvania now for failing to pay credit card bills. Tom is still squeaky clean. Well, they decide to sell the house now and move back to California. Do those judgments against Rita have to be paid at closing? They own it as husband and wife, so the answer is no. Judgments against one spouse do not attach to the property when title is held as tenants by the entirety, spouse and spouse. So again, that is one of the benefits of holding title as tenants by the entirety. You might run into a situation with your clients where they're just having a temporary spate of bad luck and can't pay their bills because maybe one of them lost their job, which we saw a lot of this during the pandemic. It might take a while for the spouse to get back up on their feet, but in the meantime, judgments might be filed out there. If your clients own the property as tenants by the entirety, we don't need to worry about paying those at closing because they won't attach to the property. Another question. We have Alex Rodriguez and Jennifer Lopez. They have no plans to get married right now, but they are buying a house together in Long Level. They want to take title so that their adult kids from former marriages would have an interest in the property if one of them dies. How should they take title? They have no plans to get married. They want to make sure that their adult kids from former marriages will be able to have an interest in this vacation property. They should take title as tenants in common. If one of them would pass away, their share passes to the estate, and their kids, their heirs, would benefit from that. So just another explanation of why a client might choose to be vested in different ways. Does anyone have any questions related to the webinar at this time?
You are recording this, correct?
Yes, that's correct.
Okay, good. I was late.
It's okay, Omer. And we're going to share all the slides for the presentation as well in an email that we're going to send out to everyone so that you can go through the slides and review them as well. So it's helpful for everyone.
I have a question.
Oh, sorry, go ahead.
If we have a listing, are you okay to pull the deed for us to check?
Yes, absolutely. Because
Great.
it's always great to know what you're walking into. And actually, even before you go to that listing appointment, it's always great to have your title agent pull that deed before you walk into that listing appointment so you know exactly who the titled owners are.
Thank you. Appreciate it.
Of course, your title company is going to keep you abreast of any judgments that your sellers might have against them and whether or not they'll attach. So armed with that information, it's possible that you as agents might need to go back again to your seller net sheet and update those so you can have a more accurate idea of what kind of proceeds your seller is going to receive from the property, and hopefully prevent any surprises on closing day.
Correct.
So if there's any other questions, I'm happy to answer those, or we can even take those questions, you can email those to me, or you can even send them to our settlements email. We'll pick them up and go through them. But I want to thank you very much for taking the time to be with us this morning and enjoy Tuesdays at 10 a.m. with Title. So thanks so much, guys. I appreciate it.
Thank you, Jerry.
Thank you.
Bye.
Thank you.
Thank you very much.
You're welcome.